Good evening and welcome to Lawyers on the Line. I'm Paula Polasky, a lawyer with the Falsani Balmer, Peterson, Quinn, and Beyer Law Firm, and this evening's moderator. Tonight's topic is premises liability. People can suffer severe injury when on the property of others, whether in a hotel, restaurant, store, or apartment building. You need to know the rights and obligations of anyone involved in such an injury. I'm pleased to welcome tonight's panelists, Steve Reyelts of the Reyelts Law Firm, Jim Peterson of the Falsani Balmer firm, and Stephanie Balmer of the Falsani Balmer firm. Steve, Jim, and Stephanie are ready to answer your questions about premises liability. Please call us at 218-788-2844, or if that's long distance for you, call our toll-free line at 1-877-307-8762. Well, let's start tonight with a question that is not too uncommon, dealing with snow and ice here in northern Minnesota. So Jim, can you start us off? Can you tell us a little bit about the limits of suing someone that hasn't shoveled or de-iced during a snowstorm?
Sure. Well, in general, a property owner has a duty to keep his or her property safe for people who come onto the property. And one of those is to remove hazards. Snow and ice would be considered a hazard, and you have a duty to do something about that. Shovel it, plow it, ice, sand, whatever it is, to make sure that it's not a slippery hazard for someone who comes onto the property. There are a lot of more special rules. For example, you don't have a duty to remove the snow or ice hazard until a reasonable time after the precipitation has stopped falling. You know, a lot of times what happens in the, either the early winter or late winter, spring, is we get an ice storm and everything's really slippery. Well, you don't have a duty to do anything about it until it stops icing, and then maybe for a reasonable time afterwards.
Okay, thank you. And Stephanie, there's something called an open and obvious hazard rule. Can you tell us what that means?
Well, when a lawsuit has been commenced by an individual who was injured on someone else's property, there's usually some discussion as the case progresses about how obvious the hazard was. So if we're talking about snow and ice, did the individual who slipped or fell on the snow and or ice notice it ahead of time? How obvious of a hazard was it? And the reason that's important is because if the court or the jury or some other decision maker concludes that the hazard at issue was so open and so obvious that it's not fair to push that responsibility onto the landowner. In other words, the individual should have picked up on it and not walked there or stepped there, or whatever the case may be, then under some circumstances the case can't go forward. There's an exception that gets a little complicated, and that involves a situation where the hazard is so open and obvious that even the landowner should have picked up on it and done something about it. So, for example, if you have a patch of ice that was very large and everybody knew about it, say at the opening to the mall, the Miller Hill Mall, and everybody's walking around it and there were all these complaints and everybody knew about it, well, yes, the argument could be made that the individual who slipped and fell on that shouldn't have walked there, but so too would you argue that the people at the mall who were responsible for maintaining that also should have done something. So it depends on the fact situation, but that's generally the idea.
Well, the other thing is a good lawyer who may be representing the property owner, like Steve, is going to make two arguments. One is the hazard was open and obvious, but another argument is the landowner had no way of knowing that it was there. And while those seem to be kind of contradictory, they're both available as a defense for a landowner. And sometimes it makes it real hard for somebody representing an injured person, because number one, you have to prove that the property owner either knew or should have known of the hazard, but two, it wasn't so obvious that any idiot would have seen it and not injured themselves.
And also the open and obvious defense doesn't necessarily just apply to snow cases. I mean, we've successfully defended cases where there was packed snow that someone chose to walk over even though they could see it. But also, in a situation, we've had cases where there was a darkened stairway without lighting that someone fell down, but because that person was aware that it was in a rustic resort and that there was this had been up and down the stairs many times and knew that it wasn't lit and chose to go through that stairway in the middle of the night, that was considered by the court to be open and obvious, and the case was dismissed. Another was where a fellow slipped and fell in a pool of oil in the middle of the garage at his mother-in-law's house, sued his mother-in-law. But there he used that garage to work on his cars. He knew that oil slick was there, and it was right there in the middle of the garage, and slipped on it. So that, again, another open and obvious case that was successfully defended. So it just doesn't apply to ICE cases too. There are all other kinds of types of open and obvious situations.
Now we've got some really good questions coming in already. I'll throw this out to any of you. There's a couple relating to people that break into a property and get injured. So for example, this question says, there's an old barn, an old garage on the property. There's a no trespassing sign posted, which is padlocked. If somebody breaks in and gets injured, are the landowners liable in a situation like this?
Well, Minnesota has currently two standards for premises liability, essentially. Okay, one is for what we call an entrant, which is anybody who's lawfully entitled to be on the property. Doesn't matter whether they were invited or it's for business purposes. If you're lawfully there, there's one standard. There's also what we call the trespasser standard. If you're a trespasser, you're in a place you break in, you're just not lawfully there, maybe you're cutting through somebody's yard or whatever, and you get hurt, the only way that the property owner is liable is if the injury was caused by the affirmative actions of the property owner, okay? For example, if this comes up once in a while, you know that there's kind of an unofficial path that people take on their snowmobiles through your property, so you put up a strand of barbed wire across it to stop them, and then this happens.
People do that?
And that's an affirmative action that if somebody gets injured, then you're liable. But it's got to be some sort of an affirmative action by the landowner to trigger liability for a trespasser.
Okay, so in the non-trespasser instance, so this question says, if a relative is working on my roof and they end up getting injured, am I liable for that? Stephanie, do you want to take that?
Well, my lawyer answer is depends, but I actually handled a case a lot like this. Yeah, these cases go to the facts of each case. So if someone's working on a roof and they're doing so in a casual manner, and there isn't anything patently dangerous about it beyond the fact that you're working on a roof, I would say that's a hard case. You're on a roof, you have the chance of injury. If there was a hazard that the homeowner knew was there and hadn't taken any steps to either notify the relative working on the roof or to fix it, then there may be something there. Because it really goes to whether the landowner took the appropriate steps that a reasonable person would. So you have to ask, what would a safe and a reasonable person do in this case when they invite a relative or anyone for that matter to come over and help work on their roof? Alert them to a particularly dangerous hazard? You'd like to think so.
Okay. Now, Steve, I'm going to ask you about this one. There's a couple questions that came in regarding suing a bar if you get hurt on their property. Somebody asks, leaving a bar, early in the morning around 2 o'clock, had some beers during the night, ended up falling in the parking lot. Is there anything that they can do, and what other circumstances are involved in suing a bar that you get hurt at?
Well, bars or hotels or other businesses have a duty to keep a safe premises, just like any business does. So there's that. But then there's also there are also special duties for innkeepers, which includes bar owners, hotel owners, too, about people who might be hurt on their premises, caused by the actions of another. For instance, the typical bar fight case. There's a whole area of premises liability where a bar can be responsible if the bar management knew that the person that was involved in the fight and hurt someone else had dangerous propensities. So there's that responsibility for bars. And with respect to slip and fall cases, a bar or a restaurant has the same duties that other owners of land or possessors of land have to people on their property or on their adjacent property. Of course, as you point out, with a bar, there's always a question, well, was that person responsible themselves because they had a couple of drinks? And that's one of the factors that a jury would decide, comparing the fault of the person who slipped and fell and the bar, and who was at fault. And back to the general questions about slip and fall, that's always a factor. So the owner of the property may be at fault for not shoveling quickly enough, or for not maintaining the walkways. But there's also the question of whether the plaintiff himself or herself was responsible, not only for encountering open and obvious dangers, but also what kind of footwear was the person wearing? Was it appropriate? Was the person drinking? Were they paying attention? Nowadays, how many people fall while they're texting? So these types of indicia of fault on the part of the plaintiff are considered too by a jury. Just what was the action of the plaintiff before they fell?
Okay. Now, in Minnesota, we do have a lot of people that snowbird in the winter, where people go south to escape some of what we have to deal with here. One viewer is asking if I'm a property owner and I'm away for a few months in the winter and I'm not able to keep my driveway clear all the time, am I liable to people that get hurt on my sidewalk or on my driveway while we're away?
On the sidewalk, I would say yes. You have an obligation to maintain areas that you reasonably expect people to be traveling on. The driveway, unless you expect someone to come in there, I don't think that would be as much of an issue.
I guess that's a follow-up question. Sidewalks, are they maintained? Is the responsibility for maintaining sidewalks on the city, or is that something that falls on each landowner for the portion that is outside their home? Does anybody know the answer to that, or Jim?
The sidewalk is the responsibility of the adjacent property owner in most cases. Mm-hmm.
Okay. So there's a lot of really good questions coming in. This person slipped and fell on city property. What would be the first step they would take if they were injured? Steve, do you want to take that?
Well, with the municipality, you have to put the municipality on notice, and municipalities have special defenses like immunity defenses because municipalities take care of all kinds of roads and sidewalks. But the first thing to do is put the municipality on notice, through a lawyer. I mean, you talk to one of these two people to my right or to you, and get the legal help right away, because there are hoops you have to go through if you're going to make a claim. So that would be my advice. If you've slipped and fallen on municipal property.
Yeah, cities and government entities in general are rarely responsible for a slip and fall type of event. Okay. The statute says that a government entity, a city, county, whatever, is not liable for failing to plow a street. They may be liable for negligently plowing, and there's some cases where if somebody plows a road and leaves a big pile of snow in the middle and that causes an accident or something. But other than that, they're not liable for failing to plow, and they're not liable for slippery sidewalks that you slip and fall on, unless you can prove that that condition had existed for a long time, and it really says in the law by the condition of the ice. Was it smooth and shiny? Then they're not liable. Did it have hillocks, furrows, and what are the other?
Rough and uneven.
Rough and uneven surfaces? Well, then maybe. And I lost that case, and I know very well that's the, yeah,
Not going to forget it, I see.
no.
Get over it, Jim.
Yeah.
Some people are wondering about special dangers that might be on someone's property, such as a swimming pool or a trampoline. Say the neighbor's kid comes over for a birthday party and their child jumps on the trampoline and gets hurt. What does that scenario end up looking like? Stephanie, do you have?
I believe, because not only in the course of my practice, but also just from casual discussion, there are actually some homeowners, insurers who aren't insuring homeowners if they have a trampoline. I don't know much about swimming pools. Not a lot of swimming pools around here, but I guess my practice and my common sense says trampolines are really a tough thing. They do tend to cause injuries. Is there an automatic law that says if someone gets injured on your property while using one of these giant toys? No. Is it going to be harder to say, I had no idea anybody could ever get hurt here? Yeah, I think so. As far as swimming pools, I think that goes to a standard of care as far as keeping an eye on everyone. I believe there's been some discussion statewide about who should be around to watch kids when they're swimming. That's in a school setting, but I think there's been a lot more attention paid to that issue as of late with the drownings down in I think it was Golden Valley. And I just think it's a bad idea. The cautious side of me says don't have a birthday party at your swimming pool. I don't know.
A lot of lawyers' kids have never been on a
Oh,
trampoline.
I couldn't do anything growing up. I couldn't wakeboard. I couldn't do any of that. No.
My kids have never been allowed to be on a trampoline because I think it's inherently dangerous, but it's also what we call an attractive nuisance. If you have a trampoline in your yard and you're not home and if you put up a sign that says stay off, it's something kids are going to want to go jump on, and that I think may expose you to some liability if there's an injury.
Interesting sideline. These two lawyers to my right are also children of lawyers, so apparently
We
there's
would
some
know.
emotional scars that we're hearing
Well,
about here.
I had to sneak to use the trampoline was the problem. So, yeah. But I'm still here, so.
Well, swimming pools are, insurers are, of course, are very leery of swimming pools and they have to be fenced in. Another thing that wasn't mentioned in the question, but docks. Docks are a huge potential liability area as well.
Yep, that's actually one of the questions that's here. It's a child comes over and gets injured on the dock and then and ended up passing away. So, which is incredibly heartbreaking. But so that's
I have
that's
talked
another-
to an expert, a guy who claimed he was, he had a degree in recreational science or something, whatever that is. But he said that, and he was willing to testify on a case of mine, that if you expect strangers or guests to use your dock, you should measure the depth of the water every couple of feet and mark it on the dock. Okay, so if it's only 3 feet, you should put a 3, just like at a swimming pool. He said that's a standard of care. I don't know anybody in the world
I have never seen
who
that.
does that, but
Yeah.
he was willing to, and this was a case where a very serious injury had occurred, and he was willing to testify that the property owner in that case was at fault. It was a commercial property, not a cabin or something, but that they had an affirmative duty to tell everybody how, because it was a little bit deceptive how deep the water was in one particular spot off the dock. It was only 4 feet instead of 10 like you would have thought, apparently, and so that, yeah, very serious thing, and I don't know if that would be found to be the duty of care, but it could be.
And just playing devil's advocate here, as far as depth of water in a dock, I, as an adult, would just never jump off of a dock. I don't even know that I would jump feet first because these Minnesota lakes,
Yeah,
I don't know what's down there.
There's definitely also standard of care for the person jumping or diving, that's
Right.
for sure.
Right. So another interesting question This person is wondering, am I responsible for my child's guests at a party, and if somebody brings alcohol? So say there are teenagers, not a completely uncommon scenario, unfortunately. So,
Steve is the guy on this one.
okay.
Yeah, that's right
Steve,
up my
wanna
alley.
take
We
this?
do a lot of liquor liability defense work, but, you know, in Minnesota, social host liability is a big issue these days. There are many municipalities have criminal statutes or ordinances that make parents and homeowners responsible for what their kids do. But with regard to civil liability, here's the rule. If a parent or the possessor of property is aware that minors are drinking on their property, and if that person who's in control of the property can reasonably do something to reasonably prevent that drinking and doesn't, then that property owner, parent usually, can be responsible for injuries caused by that drinking, such as if your kids have guests over and you're upstairs and they're downstairs and you know they're drinking, and one of the kids gets drunk and drives off and injures someone, you as a parent, if you were aware that the drinking was going on and you could reasonably stop it and you didn't, you can be responsible for the damages caused to that other driver. So that's an expansion of what the law used to be. There used to be no social host liability, and then the legislature remedied that by passing a statute indicating that if you knowingly served someone under 21 at your home and you were over 21, then you could be responsible. Now it's been expanded further so that if you know there's drinking going on in your house by minors and don't do anything about it, you can be responsible.
What's the status of insurance on that? I know there was a case a couple of years ago where the court held that standard homeowners insurance didn't provide coverage, so you'd have like personal liability.
When the law was first enacted, making social hosts responsible, the law had a specific provision about insurance coverage. Your homeowner's coverage did not apply. So there was, and for a period of 2 years, no homeowner's policy could be construed as applying to this situation. Now, if you want coverage, most insurance companies will not offer a rider or an endorsement that covers social host liability. Some do. They say, look, this is a risk. It's something we should be providing to our insureds. Of course, usually there's an extra premium for it, but with some companies you can buy coverage, but you know, unless there's a specific endorsement, there isn't coverage for this type.
It's got to be a tough conversation with your agent.
Yeah.
Can you cover me in case I have a party where a bunch of teenagers get drunk?
Hopefully the agent would keep documentation of that conversation.
Okay, time for just a couple quick questions. So, for snowmobiling, if I have a snowmobile trail that goes through my property, is that a problem for me? Any of you?
Well, there's a couple of issues I already mentioned. If you do something crazy like put up a barrier or do something that causes a hazard, then you may be liable. Short of that, probably not, because of something what we call recreational use immunity. As the owner of a property where there's a state trail, you're liable only under the trespasser standard. So if, for example, a tree falls down and someone runs into it, you're not liable.
Unless it's not a state trail. If it's just a casual trail that they're using for their friends and family, I would say, I mean, if you're inviting people and it's not otherwise regulated, you may have some degree of duty to maintain it.
Okay. And quickly, there's dog bite law in Minnesota. Say the neighbor's dog bites me. What sort of liability is there in Minnesota for that? Is a strict liability where they're liable no matter what, or what is it?
Yeah, it's pretty much almost strict liability where the dog owner is responsible, except there's one exception for provocation. So if you're if the person who's bitten is provoking the dog, then there's an exception there. But otherwise, the dog owner is pretty much responsible for what occurs.
In Wisconsin, it's the same rule, except if it's a second bite, if the dog has bit somebody before and you know about it, then you're liable for double damages the second time. So there's kind of an add-on penalty for that.
Okay. Now that's all the time we have for tonight. Remember, you can watch our show again online at www.wdse.org or www.duluthtriallawyers.com. If you have additional legal questions, you can access the Volunteer Attorney Program's Ask an Attorney service. Please join us again next week when we'll be talking about family law. I'd like to thank our panelists for their expertise this evening, and thank you for watching. I'm Paula Polasky. Good night.